Good morning. I'm Eric Blank. This is the Commissioners' Weekly Meeting for Wednesday, January 24th, 2024. Commissioner Plant, any preliminary matters? Are you ready to approve the consent agenda as presented?
I am ready to approve the consent agenda.
Commissioner Goodman.
Good morning. I too would vote to approve the consent agenda.
As would I. Thank you. Proceeding number 23AL-0631G and maybe 635G and 636G construction allowances. Mr. Davis, I don't know if we're going to take them as a unit or one at a time.
Yes. Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff. And yeah, I would like to present the three tariff filings. The first three items on today's discussion agenda together. These are filings that were made by Black Hills Colorado Gas, Colorado Natural Gas, and Public Service Company of Colorado. They were submitted with the Commission pursuant to Senate Bill 23291. That bill includes provisions that require each of the four investor-owned gas utilities in Colorado to file with the Commission no later than December 31st of last year an updated tariff to reflect the removal of any incentives for an applicant to establish gas service to a property. The statute states that a gas utility shall not provide an incentive, including a line extension allowance, to establish gas service to a property. And the statute defines a line extension allowance to mean a bundle of costs that includes construction allowances for new service lines, meters, and other infrastructure associated with the addition of the new customer to the gas utility's distribution systems. Atmos Energy actually was the first of the four utilities to file tariff sheets reflecting revisions to its line extension policy. Staff of the Commission filed a protest to Atmos's filing, claiming that Atmos eliminates only the company's construction allowances for service lines, and further explaining that under the provisions of the new law, the construction allowances for service lines constitute only one component of the incentives that must be removed from a gas utility's tariff. According to staff, Atmos's proposed tariff revisions do not include the removal of the incentives of a provided meter or other infrastructure associated with the addition of a new customer, and gives a service regulator as an example of that. So at the December 27th weekly meeting, the Commission set Atmos's matter for hearing and set a notice of intervention period. But now that all four utility filings have been filed and are available for the Commission's review, I'd like to present the filings this morning for Black Hills, CNG, and Public Service, and to discuss briefly the provisions for line extensions in the Commission's gas rules that were adopted just prior to the passage and signing of Senate Bill 291. So for Black Hills filing, that's primarily a red line tariff. The three main changes that Black Hills makes are first, the introduction of a definition of a meter set, and then a set of fees that new customers must pay to Black Hills as a reimbursement for this meter set. Second, the elimination of the construction allowance generally. And third, new provisions for what we call grandfathering of the construction allowance. And that is that the construction allowance would be available to certain new customers whose line extensions were installed prior to August 7th of last year, and that was the date when 23291 took effect, or to new customers who had submitted an application prior to or pending on August 7th, and who had submitted a permit application to the local permitting authority, and that was either approved or pending as of August 7th. The proposed effective date of Black Hills tariffs is January 29th, and no protests have been filed. Turning to CNG, its filing is also made up of revised tariffs. They show two main changes. First is the discontinuance of the construction allowance, and then the new provisions to clarify certain continuing eligibility for customers to receive an allowance, and that's presumably in accordance with the section of 291 that allows for that grandfathering. CNG states that it filed this advice letter under protest. That is, it argues that 291 violates the contract clauses of the United States and Colorado Constitution, and that it also violates the taking clauses of the US and Colorado Constitutions. The proposed effective date of CNG's new tariffs is much later than the three other utilities, or April 29th. CNG states that this extended effective date is intended to allow for these legal issues raised in the advice letter to be addressed in the appropriate forum. Now, on January 5th, staff filed a protest to CNG's advice letter filing, stating that the plain language reading of the new statute means that incentives must be removed that include not just the service line construction allowances, but the costs of other infrastructure or meters that are associated with the addition of new customers. So staff has asked that the commission set the matter for hearing because it's concerned that CNG's filing may not satisfy the statutory requirement to file the removal of any incentives. In addition, staff suggests that the commission might benefit from additional legal analysis and briefing regarding CNG's claims that the new law violates the constitutions. And on January 18th, the Colorado Office of the Utility Consumer Advocate filed an intervention and request for hearing, saying that it shares the same concerns as staff raises in its protest. And finally, Public Services also seeking to modify its tariffs, and its filing is primarily a red line of its existing tariff sheets. What's unique about Public Services filing, however, is that it also seeks to clarify through this tariff submission that there are no charges for voluntarily and permanently terminating gas service to properties. Now, that provision is consistent with another part of Senate Bill 291, but that provision is not tied necessarily to this December 31st, 2023 filing deadline. So the four changes for public service are the removal of the construction allowance, new provisions similar to what's in Black Hill's filing for the grandfathering, updates to the tariffs to raise the fee for the meter set from being 50% of those costs to all of those costs, and that language to clarify that customers who voluntarily and permanently terminate gas service will not incur a charge or fee unless otherwise permitted by the commission. The proposed effective date of public service tariffs is February 1st. And as with Black Hills, no protest has been filed for that advice letter. Now, I mentioned to you that 291 was passed by the General Assembly and signed by the governor shortly after the commission finished promulgating new rules for gas utility line extensions. These new rules were in effect at the time the gas utilities made their advice letter filings in December. Rule 4210 states that line extension policies, procedures, and conditions shall be based on the principle that the connecting customer pays its share of the estimated full incremental cost of growth, including any costs associated with increases in design peak demand. And Rule 4210 states that a line extension allowances shall be updated pursuant to Rule 4210C in a base rate proceeding or in a separately filed application, but should be implemented no later than December 31st. So now that all four line extension policies are before the commission, pursuant to the filings required by 291, it's time to address how to best move forward with these cases. This morning, we'll do that for Black Hills, CNG, and Public Service. Atmos's filing is still out on notice and intervention and will return to a weekly meeting after that ends in early February. So I can proceed now to a recommendation. After that long setup, I can answer questions or listen to your discussion.
Yeah, why don't you give us a recommendation, and then we'll come back with vote, comments, questions, or a discussion.
Great. So I recommend that the commission set the three advice letter filings for hearing and suspend their effective date pursuant to statute. The principal purpose of the suspension is for the commission to have the time to review the filings further to ensure that the tariffs fully implement the statutory requirement that the customers no longer receive an incentive as represented by the line extension allowance as defined in the statute. Advisors suggest that this additional time is necessary to accomplish this objective, even though protests have not been filed for Public Services and Black Hills tariff submissions. All four gas utilities have now submitted their filings, and we suggest that the commission waive on its own motion the December 31st, 2024 deadline that's in Rule 4210D. A waiver of that deadline would thus leave further examination of these line extension policies to future base rate proceedings whenever they are filed. This approach makes sense to us because the elimination of all incentives is probably a continual process, and there are other provisions in the bill that do not neatly match the December 31st, 2024 deadline contemplated in the Commission's gas rules. Now, if the Commission agrees to waiving the deadline, we further suggest that each case be referred to an ALJ for a recommended decision. The assigned ALJ would be tasked with writing a decision that explains that the utilities tariff has been thoroughly reviewed to ensure that those line extension incentives listed in the bill have been properly removed. I think these tasks can be accomplished in less time than a full rate case, as this may just be a matter of taking some additional time to ensure that staff and others have had plenty of time to review the filings to ensure all of the removed construction allowance costs as defined in the statute are no longer being offered to new customers. With the waiver of that December deadline, the Commission has the opportunity to clarify that those rules 4210C and D remain in effect and they're applicable to the gas utilities, and that in base rate proceedings that are filed after the effective date of those rules, line extension policies will be reviewed in accordance with those specific new provisions. Those provisions in the Commission's rules are not inconsistent with or contrary, in my view anyway, to any of the requirements in Senate Bill 291. And in addition, it seems that the timing of the filings contemplated in 291 is an indication that, except for the grandfathering provisions, construction allowances are to be eliminated as soon as feasible after the effective date of the new statute. Regardless of whether the matters are referred to an ALJ today, the Commission should include provisions in the suspension orders to establish a 30-day notice and intervention period for each case. So in summary, it would be a waiver of the December 24 deadline, setting each of the tariffs for hearing, suspending their effective date, referring the matters to an ALJ, and setting a notice and intervention period.
Commissioner Plant?
Thank you. And I agree with the recommendation. I just have one quick question. So as it relates to the CNG issue, that's being litigated or that's been referred to a district court or something? Is there any?
I don't know whether anything has happened in the courts, but the matter would go to an ALJ and the ALJ would explore with the parties in that case whether it was necessary at the Commission to review those issues and to explore further what CNG means by saying that it's going to address those legal issues in an appropriate forum. I think an ALJ can handle that well, and at this point, CNG's filing shouldn't be treated any differently than the other three.
Okay, great. Thank you for that clarification. I agree with the recommendation.
Commissioner Gilman?
Thanks, Mr. Davis. Yeah, well, I agree with your recommendations. I think it's reasonable for us to send these discrete issues around the line extension allowance, each to an ALJ to ensure we have consistency and ensure the totality of what should be considered in those line extension allowances has been removed from any of their tariffs and policies. I would point out, I think expediency is helpful and important here. Since this is a fairly discrete issue, it's important to ensure we move forward with the obvious or non-controversial portions of this as quickly as possible, I think, to ensure that we don't inadvertently extend those incentives any longer than the legislature had intended through their language in the bill. And then I just want to come back to one of the other issues you kind of brought up in your discussion. I think it's important for us to continue to think about what ongoing compliance with this legislation looks like as we move forward. I think these filings essentially address and will continue to address the issues specific to the line extension allowance, which is defined in statute. But the statute uses line extension allowance as only one example of the type of incentive that must be removed. And in this way, I think there's a significant role here in continuing to look at these issues and any potential subsidies or incentives in an ongoing way in each future rate case filing of the LDCs so that we can ensure that we continue to comply with the statutory language here to ensure that all incentives have been removed. So maybe I would just add that, and would appreciate if we could have language expressing those sentiments if my colleagues agree, including, I think, the urgency to the ALGs to, you know, find us some consistency here and moving forward with the line extension allowance piece, but to do so in an expedient way so that we don't delay what the legislature intended, at least for the non-controversial portions.
Yeah, I would support Commissioner Gomez' request to emphasize the need to move quickly and not somehow at this time let the perfect be the enemy of the good. And I'd also support a request to reiterate that we want to continue to look at compliance with the legislative guidance in a broader and more full way as we continue on through rate cases and other proceedings. So I strongly support Commissioner Gomez' request to add that type of language to our order. Commissioner Plant, are you supportive of those two things, or would say it different? Or
Nope, that sounds sounds good, and I agree with the amendment.
Mr. Davis, does that? I think there'll be 3 separate ABC orders. Does that give you enough guidance to draft them?
Yes, it does. Ms. Dundas and I will get those drafted and issued as soon as possible. Thank you.
Thank you. Mr. Greenberg, proceeding number 23A-0216G, Atmos Energy Corporation's application for a demand-side management strategic issues proceeding.
Yes, good morning, Commissioners. Dan Greenberg of your advisory staff. Atmos filed its strategic issues application on May 1st of 2023. Staff, UCA, and CEO intervened, and SWEEP and Energy Outreach Colorado were granted intervention. Following submission of answer and rebuttal testimony, all parties signed on to a unanimous but partial settlement agreement on November 2nd of last year. The sole issue left unresolved by the settlement was whether Atmos Energy should be required to implement a beneficial electrification program. Staff, UCA, and CEO took no position on this issue, but SWEEP and the company subsequently filed testimony arguing their positions. ALJ Hahn filed her recommended decision R24-0016 on January 9th, approving the settlement and deciding that she would not require Atmos to include a BE program in its next DSM plan application. Exceptions to the recommended decision are due on January 29, which is less than 1 week away. The only decision point for you to consider today is whether to stay the recommended decision to provide additional time to consider the terms of the settlement and the ALJ's decision regarding beneficial electrification. If you decide to stay the decision, this matter will return to a future weekly meeting for a decision on whether to adopt the recommended decision with or without modifications. But the due date for exceptions will remain unchanged by your decision today. So I'll pause here for any questions, your deliberations, or I can provide a recommendation.
Yeah, why don't you give us a brief recommendation, Mr. Greenberg?
Sure. Advisors recommend that the recommended decision be stayed to allow the Commission additional time to consider settlement provisions and the ALJ's decision regarding beneficial electrification.
Commissioner Plant?
I agree with the recommendation.
Commissioner Gomez?
I also agree.
As do I. We can take a look at it. And I think that can be, I guess that's an ABC decision, staying the recommended decision, Mr. Greenberg?
I believe so, yes. Great, thank you.
Thank you, sir. I think that concludes the agenda. An easy, quick day. Commissioner Plant, any final thoughts before we adjourn?
Nope. I have no final thoughts. Thank you very much.
Commissioner Gilman, any public service announcements today?
I don't think I have any today. Thanks though. Appreciate the opportunity.
Thanks to all. And with that, we're adjourned.